Next week, the U.S. Supreme Court will hear challenges to Proposition 8 and Doma, the Defense of Marriage Act. They're arguably the two most important cases involving gay rights ever to go before the High Court. First case on Tuesday will be Hollingsworth v. Perry, a challenge to Prop 8, a voter initiative that banned gay marriage in California, about 6 months after it was legalized by the state Supreme Court. On Wednesday, the court will hear United States v. Windsor, a challenge to the Defense of Marriage Act. At issue here is whether Section 3 of Doma, which defines marriages between a man and a woman, violates the Fifth Amendment's guarantee of equal protection under the law as applied to persons of the same sex who are legally married under the laws of their state. Joining me now is Dean Hara, widower of Representative Gary Studs, the first openly gay member of Congress, and a plaintiff in Gill v. Office of Personnel Management, which challenges Section 3 of Doma. Dean is now waiting to see if the Supreme Court will take up the case. Camilla Taylor, Marriage Project Director at Lambda Legal, a national legal organization committed to recognizing the civil rights of the LGBT community. Professor Melissa Murray from UC Berkeley Law School, where she teaches family law, criminal law, and advanced topics in family law. It's great to have you here. It seems to me that given Kennedy's record, he's going to be pretty amenable to the arguments made in the Doma case specifically. Do you think that's right, Camilla?
I think that's absolutely right. And I think actually law professors of a gambling nature around the country are all very confident that Doma will be struck down. I think a lot of them are expressing a lot more interest in discussing what the various outcomes would be in Perry because there's such a feeling of confidence that Doma is so demonstrably unconstitutional and that it's a safe thing to strike it down because to strike it down is in fact a very conservative thing to do. There are a lot of very conservative arguments for why Doma should fall.
What are those arguments?
Well, what the federal government did was unprecedented in saying that it was going to fail to respect state law determinations of who's married. And the federal government's never done that before. And we can all think it would be ridiculous for a non-gay married couple in Arkansas to be denied a federal benefit like Dean was solely because the federal government has its own determination of who's married, and they're going to decide that Arkansas's laws don't comport sufficiently with its own notions, and the federal government's never done that.
The Doma case we just mentioned, there's, I think, more of a sense that it's got better shot before the court. The Prop 8 case is a little more complicated. Why is the Prop 8 case more complicated? Why is there less of the confidence, I think, about what the court's going to do there?
Well, there are a number of ways that the Prop 8 case could come down. It could result in a ruling, conceivably, that requires all states around the country to issue marriage licenses to same-sex couples. Or it could do something more limited.
Wait, let's stop there. That would be a very big deal, just so we're clear, right? This would be a declaration by the court that that marriage is a constitutional right. I mean, that would essentially be what the declaration is, right? That it is unconstitutional to discriminate on the basis of sexual orientation in the provision of the institution of marriage.
Absolutely. It could do so either on equality or liberty principles. So it could decide either that it's a fundamental right to marry for all of us, regardless of sexual orientation around the country, or it could decide as a matter of equality principles that all marriage bans must be struck down. Or it could do something more limited. It could do something along the lines of what the Ninth Circuit held, which applies in a very direct sense exclusively to California, pointing out that there's something novel here, that the state of California determined that it was a fundamental right under the state constitution for same-sex couples to marry, and then the people of California, by a very narrow margin in Proposition 8, chose to take that fundamental right away.
I want to read from Judge Vaughn Walker's opinion in Perry v. Schwarzenegger, which is the circuit court.
District court.
The district court opinion. Although Proposition 8 fails to possess even a rational basis, which is an amazing sentence to write, which is basically saying, all laws, before you even get to the Constitution, right, you have to have there has to be a rational basis for laws. He's saying it even fails rational basis test. The evidence presented at trial shows that gays and lesbians are the type of minority strict scrutiny was designed to protect. The trial record shows that strict scrutiny is the appropriate standard of review to apply to legislative classifications based on sexual orientation. Explain the meaning of strict scrutiny in constitutional law and why that's such a meaningful sentence by the district court judge.
Well, there are some classifications, for example, if a law singles out people because of their race or because of their sex, that warrant a greater degree of skepticism by courts in looking at those laws, because we know from our history as a nation that there's been a history of discrimination against those groups, and that the color of your skin or your sex doesn't have anything to do with your ability to contribute in society. And so courts will accord either heightened scrutiny in the context of sex or strict scrutiny in the context of race in order to make sure that the state bears the burden of showing why it's important.
And we could come out of a decision in these cases that does the same for LGBT folks in this country.
That's right. And who has the burden is very important, not just in the context of marriage cases, of course, but if you are considering an employment claim of discrimination by a public school teacher.
This could be a real sea change. I want to thank Dean Hara, widower of Representative Gary Studs, the first openly gay member of Congress, Camilla Taylor, the Marriage Project Director at Lambda Legal, Dan Savage, get to it, Dan, co-founder of the It Gets Better Project, and author of the syndicated sex advice column, Savage Love, and Melissa Murray, professor at UC Berkeley Law School. We didn't get to your amazing article, Marriage is Punishment, but we'll send a link on our website. People should read that. Very thought-provoking. Thank you for joining us this morning.